Beyond the Black Letter Law by Prism Chambers, a platform where we demystify legal concepts for you. This is episode 4 of Beyond the Black Letter Law, and we're particularly excited today to be rolling out our video series. The theme that we've chosen for this new mini-series is centered around the role of the General Counsel / in-house lawyer. We've got a great lineup of GCs from around Mauritius with varying backgrounds and experience, and I'm sure you'll enjoy this series. Our first guest is, I dare say, one of the pioneers of the role of the GC in Mauritius. She was appointed Chief Legal Executive of the Rogers Group in 2007, at a time where the concept of the in-house lawyer was still very much a novel idea in Mauritius. She's also a seasoned board member and is one of the leading figures behind the corporate governance framework in Mauritius. I'm very honored to be sitting down today with Ms. Aruna Radhakeesoon. A very warm welcome to you, Aruna.
Thank you.
So, Aruna, when I was reading up on your bio prior to today's conversation, I noticed that we share a very similar start to our careers. I also qualified as a solicitor in England before moving back to Mauritius. I understand that you then qualified as an attorney here. Was it always a conscious choice to be an attorney as opposed to being a barrister?
For me, being a barrister, it's about being in court, being on your feet, and having that gift of the gab. And I always had a little bit of a delayed reaction, and I wrote very well. So the automatic choice would have been for solicitor, and coming back to Mauritius would be for attorney. And
I understand that you went private practice for a few years. Yes. Before moving in-house. What was your main motivation for moving in-house?
I think having been in the UK and having been trained as a solicitor, as you know, the articles are very thorough. I got a bit used to the corporate environment, and I saw myself having a more corporate role as opposed to the traditional attorney's role here in Mauritius. I think that was more what prompted me, and also that perhaps my intuition, which was pushing me more towards the corporate setup rather than the traditional attorney's role.
And at the time that you joined, I understand you joined the Rogers Group in 2001. Presumably at that time, the concept of the in-house lawyer was practically unheard of. Did you face any challenges on that journey?
It's true that it was not a known concept then. And I didn't join Rogers as an in-house counsel. They asked me to join first to replace the group company secretary who was retiring. And they asked me initially to train the COSEC team, to lead that team before starting legal function. So I went in as a group company secretary. In those days, the in-house function was not known, and the expectations around the in-house counsels also was not known. So once I had formed, trained and settled the COSEC team, I then added the legal dimension in there. The obstacles in those days were numerous. I think the first thing was youth. I was very, very young, replacing somebody who was retiring. With youth comes a lot of traits of character like bluntness, brash, defiance, black and white world. In a corporate setup, those traits of character do not necessarily go hand in hand. And then I was a young woman joining the corporate world, and that world was more male-dominated, and they were more used to respecting grey hair as opposed to a young woman who just landed. So it took some time to build the trust with the managers, and also they didn't quite understand what to expect from me. So one needed overtime to educate, make them feel at ease, so that the managers would come to you with their work. And then there was also that sort of tradition that finance managers wrote the contracts. For them, if you had a good command of English, therefore you could write contracts, that was it. They didn't see why it was necessary to bring a female in, a lawyer in, when they could write the contracts themselves. So it took a couple of years of training to make them understand. And I'm happy to see that that has changed. The role today is much different from what it was before. Today it's accepted. One understands what is expected from that role. In those days you needed to educate more and to add things on gradually as opposed to drastically. And I think now the role also has evolved enormously with the over-regulation that has come in. It's not a pure advising on legal issues matter. There's a heavy compliance side added to that role. If you're an in-house legal person, then you would need to look at things like contract management. How do you safekeep and keep your contracts? Because they have a tendency of remaining in the drawers. Resources move in and out of the company, and nobody's aware of what exactly we've undertook as legal obligation. And then there is the mark side, intellectual property, the registration and renewal. There's the data protection, and now there's a heavy AML CFT verification check obligations. So the role is evolving constantly.
Yes, and I think it's interesting that the way you described it, and I fully agree with you, it's a multifaceted role. And I think one of the key takeaways I took from my short time in-house when I was back in London, is that people often have this misconception that the in-house lawyer is just here to give legal advice. Do you agree with that it's a misconception?
Yeah, I think those who are within the corporate setup and who are used to dealing with the in-house counsel or the legal department would understand where they would come from. I've been in Rogers Group for 22 years now, and I think most senior managers know what to expect from the department and how to interact with us. The Rogers Group is a little bit different because under the legal department there are 3 different functions. So there would be the pure legal side, the legal advice, contract drafting and so on. And then there's the local company secretariat. We have about 160 entities. So there's a pool of company secretaries there. And I added a new dimension, which is the AML CFT verification check as well. So it's multifaceted, and they know when they come to us, if it's for an advice about how to get something approved in the board or to get a transaction approved, then they would know where to come to ask that advice. The AML CFT we impose a little bit on them because in today's world you can't do without that. So each time we are meeting with new investment partners or there are new directors coming in, then they would run through the AML CFT checks, which keep on running 24/7. And then on the legal side, one needs to take a decision whether you want to do litigation or not. We consciously decided not to do any litigation in-house, so to look at purely non-litigation side. However, we do monitor and supervise sensitive litigation cases for the group. And we have an attorney's clerk who go into court and so on, and who therefore keeps a dossier for each of those sensitive litigation cases. That's a bit how it runs within Rogers. People from the outside over time, for example, the network of external lawyers, have grown accustomed to how to interact with us. But yes, the role remains a bit of a mystery from the outside world.
Absolutely. And I understand that you've also been executive director since 2012, if I'm not mistaken. How would you view, if someone were to describe the role of an in-house lawyer or the head of legal as a business leader or a business enabler, how would you identify with that?
I think you're absolutely right. I think it's a natural evolution of things. When you start up as an in-house legal counsel, things don't come automatically. So over time, you learn to grow the trust between yourself and your clients. And you start with simple contracts, drafting, vetting, advice. And then over time, as you get involved into more complex transactions and your company, you are with them in negotiation tables and help close deals, then you become very much a business enabler. It's not just about giving legal advice, you're actually pushing to get the deal closed and finding ways to get the deal closed. And then eventually there's an evolution of things as well, because you get involved in more and more complex transactions and you're often in front of regulators and so on. And then there comes another part of because you become really a business leader there. Not only business enabler, but business leader, and over time, within the corporate world, people get to know you, and eventually you become a business leader in that field if you stay for quite a while.
Yes, and I think it's fair to say you've been a great business leader. You've been an inspiration to many women. I mean, we were on a panel on diversity recently. I think a lot of young women look up to you.
I think things were very different 20 years ago. I remember the first boards I joined, which was a shipping board. It was a very dark boardroom, full of male. You went in and they would look at you as if you came straight from a zoo. Things were very different. Today it's accepted to have women around the table, not only in terms of company secretary, but in terms of director. And it's more accepted. It's much easier than it was before.
Yes, I agree.
So that was the hard time. But I think youth, being brash, fearless, help to overcome all those obstacles and drive your way forward.
Yes, absolutely. I think that the lack of fear, I think that you mentioned last time, you probably have more fear now than you did before.
I think now we're more mature, poised, balanced, and I get things done in a more diplomatic way. Before it was very blunt. It was very defiant mode. I think it's okay for a while, but it doesn't serve you long term. So being more diplomatic in a corporate environment helps you achieve a lot of things.
I fully agree. Now, you mentioned earlier about as you go along, external counsel know what to expect of you. What do you expect of them?
That part as well has evolved over time. I think in the old days when the in-house counsel role was not there, the external lawyers expected that you would hand over the dossier to them, you would give them the instructions, and they would run it. Now a lot of that drafting, reviewing of contracts, simple legal advice, is done more by the in-house counsel. So when we go out to external counsel, it's more on specific expert advice. There's a specific legal issue which needs to be researched, analyzed, and an expert opinion given by a senior counsel. That's more what we're looking towards. Or if we're unsure about some legal matter, then we'll go and discuss. Or at times, the lawyer, himself or herself, may be in a bit of a dilemma. And it's always nice to be able to talk to an external lawyer. And then there's the whole bit about litigation. If you're not doing it in-house, then you would actually instruct lawyers outside. But when we go out now as in-house counsels, we're a little bit more demanding because we will not accept just anything. And in the same vein, I think the role of the lawyer de référence of groups, of big conglomerates, has changed as well. The sort of retainer that used to be there. There's a tendency now not to have retainers with lawyers. It's a free market. And basically when you have a legal dossier, then you would match, depending on the complexity of the dossier, with the expertise you need from the lawyer, whether you need a senior counsel or somebody who's actually 6 years post-qualified lawyer, somebody who's very good in court and who's able to twist matters right, the Sagaitan Duval type. So you would match it with the complexity of your case. And likewise, I found that there are external lawyers now who prefer not to have retainers because they want to be free to act for you and against you. So that's the evolution which I'm seeing.
Yes. One thing that I noticed in Mauritius that I haven't seen very much of, maybe it exists, but I haven't seen very much on that, is very common in Europe, in London, is sometimes you would have your external counsel be seconded into your group so that they can learn about the business and be able to better service you. What do you feel about that? Do you think it's a good thing?
There is a general feeling in Mauritius amongst conglomerates and large companies that the external lawyers are disconnected from business. And it's because of the way things are in Mauritius. If they're focusing on litigation, then they spend a lot of time in court. And they don't have the time to really give to you, to the dossier. They will do your dossier, but they will not have the time to get immersed into your ways of doing business and so on. So there's some merit in that. But I think that also, that exposure is built over time. As you work more and more with a lawyer over 2 years, 3 years, they get to know your ways and what the group likes or doesn't like, or the sensitive issues.
Yes.
It's not always easy, if you're doing litigation, to be able to find time to come in-house, to be with a group. And I suppose that's why now in Chambers you have departments that are concentrating merely on transactions, because that takes a lot of time as well.
Yes, absolutely. And coming back to your team now, I understand you have quite a lean in-house team at Rogers. What do you look for an in-house lawyer, junior in-house lawyer, and how do you go about building them up?
It's not by choice that the department is lean. I do have a boss, and I have to take instructions. From day one, he told me, I don't want a Chambers. So it's clear that I couldn't have a department of 6, 7 lawyers. I would wish that. So what I did when I set out, and knowing that in those days the in-house role was not so much known, was to take young graduates who finished their law degree, who finished their LLB, to train with me. I think the training I got during my articles in terms of drafting contracts is something which I then imparted to the younger generation of lawyers, but it's not something that we acquire here in Mauritius. It's very difficult to get that. So on-the-job training, knowing why you're using certain words, being close to the transaction and taking a distance to judge whether it's fair or not what's being put, are things which you teach. So there has been a lot of training. To a point, and I had one of my ex-lawyers who used to work who's now working for his own account, who I trained from scratch. And he reached a level where for complex transactions, he could do it on his own. That is what you're trying to do, to train younger lawyers in. And then there are some who come in because you can't just take very young lawyers. You need also lawyers who are 4 or 5 years post-qualified to be able to answer legal queries quickly if you are in a big group. When these lawyers come in, and if they are used to doing transactions, then you would refine their approach to, or for example, sometimes I get lawyers who believe that all contracts should start and finish in a certain way and should be 10 pages, 2 pages long. There's no point in that. Sometimes, depending on the client you have and for the purpose for which you're doing it, an exchange of letters would do. It's the same legal effect.
Yeah.
So making them understand there's flexibility around the type of document you use. Those are the things which you, on the job training, there's no other way in Mauritius, I think, for young lawyers to know about it. And I'm pleased to see that in other big conglomerates like CL, IBL, they have larger legal departments, like 6 or 7. And it's learning on the job, really.
Yes, and what would you describe as because we've spoken a lot about law, what would you say are the top 3 non-legal skills a good in-house lawyer should possess?
It depends where you're coming in. If you're young and you're coming in to learn, then you should, notwithstanding that you're fully qualified, you should understand that you don't know it all. Even I don't know it all. So you should always be learning. So an open mind, ability to learn is something very important. When you reach 4 or 5 years post-qualified lawyers, when they come in, sometimes they have their set ways. So that agility, being able to keep your mind open and understanding, putting yourself, self-questioning as well, with regards to transactions, will help you go a long way. When you become more senior, I think the qualities which are really important in my role, for example, is really emotional intelligence. That's the first one. In terms of when you're dealing with people, recruiting people, when you're in a transaction, when you're negotiating, understanding what your client is asking of you. There are sometimes some unspoken messages that come through as well. Understanding where it's a safe bet or safe transaction, or this one's a dangerous one, better send it outside. It's too risky for inside. So emotional intelligence is really important. Beyond that, I think people skills. Because as an in-house counsel, you will not be able to do everything yourself, and you will need to employ people. And knowing how to manage, how to grow, how to infuse that fire in people so that they work for you is very important. And then I think the last one would be corporate maturity, discernment, always willing, being always open to learn things, because even the legal world is changing, ever changing, so you need to be open to learning new things.
Yes, I absolutely agree. I remember at the time when I first came to Mauritius, I think it was about 8 years ago, things were still very black and white in my head, and I expected everyone to be like me, to think like me. And as you grow, I think it's wisdom, maturity, whatever you call it, you realize there are different shades of grey, and each person have different skills, competencies, qualities to bring to the table. So long as you have that common thread of the same shared values, you need to realize that you all form part of the same team, and to be able to see things as not so much black and white. I think that's very important. The other question I wanted to ask you is that I think in Mauritius it's quite well, all businesses, all established businesses have at least one in-house lawyer. But is there the support, the external support behind it? Do in-house lawyers have access to good continuous professional development other than what they're learning in-house?
At the moment, in-house counsels do not have an association just for them. It's something I've been talking about creating. So I'm talking with some people to get that going. Why it's important? It's always nice to have a network of in-house lawyers where you can share your experiences, and it's also an area, a place where you can come and talk about dilemmas you have and so on. This being said, all in-house lawyers would be law practitioners, otherwise you would not be able to give legal advice. So they would have their name on the roll of practitioners, and they would need to follow the IGLS CPD course. It's the same thing as for external lawyers.
Yes. So. Do you think that's enough?
No. I now talk to a lot of in-house lawyers, and I understand that some setup, for example, big banks, international banks, which have offices here in Mauritius, for example, Absa, well, they have structured training courses for their in-house lawyers. So you get a chance to go to the South African office to follow training courses, and you would go to London as well to follow those courses. And over there, what that means is that there's somebody who's thought about those issues and who've set up those training courses there. And it's much easier as you join as a young lawyer in there to follow those training courses and to move up the ladder. So you're better equipped, the schooling in itself. But most conglomerates in Mauritius, for example, Rogers, IBL, SCL, would not have that structured training. And therefore you would depend a lot on the person heading the in-house function. And then you get to do all the thinking yourself. For example, risk management, a lot of senior lawyers are now moving in that role of risk management and compliance executive role. Well, why? Because they have that exposure and corporate experience about that group, and they are able to exercise discernment on risk aspects, and the compliance come in very easily. So they can move to that role as well. So if this association were formed, and they would dispense that sort of structured training, that would certainly help in-house lawyers enormously.
Thank you. Aruna, thank you so much on your valuable insights on being an in-house lawyer. I cannot have you here without asking you something about the corporate governance framework. I know you've been chairperson of the National Committee of Corporate Governance since 2017. You launched a scorecard last year. How instrumental do you think that will be in enhancing the corporate governance framework in Mauritius?
We are not at our infancy stage in terms of corporate governance in Mauritius. We are now with our second code of corporate governance. And most companies follow the code. Although the second code is very different from the first one. The second code is about the 8 principles. And inbuilt in there is that philosophy of apply and explain. So basically you apply one principle, which is very general in nature, to your business, and you explain on your website or in your annual report how you have actually applied that principle in your business. But what we saw emerging after the first year was There are varying degree of explanations. Some explanations are very feasible, some are borderline, some are frankly not credible. So how would one go about correcting that behavior which is not appropriate in terms of disclosure? So I talked with quite a few experts, and they explained to me that there is that tool called the scorecard. In some places they call it the index. Basically, what was recommended to me was don't reinvent the wheel. There is the Institute of Directors Index in UK, there is the Bombay SNC Corporate Governance, there's the scorecard, there's the Asian Corporate Governance Scorecard, and there are also OECD principles. So basically, if you take all of that, you can draft your own scorecard. So the scorecard came for a specific purpose, was to cure that anomaly that started setting out there. It's true that in our jurisdiction, under our laws, the Financial Reporting Council would normally be looking at our reports, spotting those deviant behaviors and be lobbying or writing back to the company. But that would not have been sufficient. So that was the whole purpose of elaborating the scorecard. It took a long time, and the pandemic helped over the 2 years. It took us about 18 months to start and to wrap up the scorecard. So what I did was to reach out to the University of Mauritius, and I asked for some experts to accompany us. So they allocated 3 resources to the NCCG, and I gave them all those precedents of UK index and so on, and they produced a draft, which we were then circulated to the industry. And we held 2 public consultation workshops where we received comments, and I had to get on my feet. And luckily, when you're a lawyer and and I've been used to the dynamics of the board, you use a bit of logic and so on, you know where you get to. And then incorporating all those comments, we received about 23 written sets of comments, even from the Bank of Mauritius and so on. And so the second confinement helped us work through those comments, and then we came out with a revised draft. We actually went about to send that draft to local experts as well as overseas experts to get their feedback, and we received very positive feedback about it. It's well thought out, detailed, and so on. And I must say, during the gathering of comments session, I was very, very pleased to see that there was a lot of interest from the companies. So there is an interest out there to improve on corporate governance practices. People don't know quite how, and that's why they look up to the code and the scorecard, for example. And then we launched it last year, and then it's just a tool which you can keep in your drawer. That's not good enough. So
because it's voluntary, right?
It's voluntary. Yeah. NCG is just policy making. We're not a regulator, we can't impose things. And within the context of corporate Mauritius, I think you need to move in stages.
Yes, absolutely.
So then I wrote to all the listed companies, because I persuaded the NCCG board that it would be better for the first year to have a small group of companies to measure the scorecard, because we wanted to make sure that we could achieve the results, and then next year open it to more companies. So I then wrote to the listed companies, inviting them to participate in this scorecard assessment exercise. And we received 21 positive feedback, which is great.
It's amazing.
Even State Bank of Mauritius was that matter.
Very good.
So, and then we identified an audit firm through a tender process that was going to do the sifting. It was Pricewaterhouse, which won the tender, and they're used to that through the Corporate Reporting Award. So they did the first sifting of the publicly available info of the 21 companies against the scorecard. And then we appointed 3 jury panels with people coming from ranging background to actually, so PwC then presented their results to the jury panelists, because the scorecard is divided into 3 parts, so that's why we have 3 jury panels. And there was discussion and so on, and they validated the results of PwC, and the scorecard assessment report is due to come out this month. So we will have, I'm very excited, because it's not the preparation of the scorecard, that was very painful and everything, it got done. But it's seeing those results that will come out, because then you can see where you are, you've measured. You know where are the areas where we're weak, where we need to work on. And then year in, year out, as we measure, we'll see our progress. So I'm very excited about that.
Yes. And as I was reading up on it, two things struck me, and correct me if I'm wrong. The first one was that for that initial assessment, it's a one-way street. So you don't invite for interviews, there's no dialogue. The second thing is that it is based purely on public disclosures. Yes. So is that how it's meant to be, or will it evolve eventually to?
The first part, which is just using publicly available info to measure, will evolve with time. We needed to start somewhere. That's why it was easier rather than calling people in for interviews. So perhaps as we gain in maturity on the scorecard, we can move into that phase. Let's not forget that the whole purpose of the scorecard is to enhance accountability and disclosure. So the measurement of information which is available in the public domain is the right target, right? Because you want to improve on the quality of that publicly disclosed information. So that's the idea.
Yes. Yeah? And I think I'd love to have you for another conversation just about corporate governance, because that's a topic on its own. Aruna, before we finish, I understand that you're leaving the Rogers Group after more than 20 years there. What's next for Aruna?
I have thoroughly enjoyed my 20 years at Rogers. I think it's been a great learning curve. I've been very passionate in what I do. I've trained a lot of people, some who have left for other companies. But you know, it's about finding the right balance between work and your life as well. And I think I reached a stage where I need to focus a little bit more on my personal life, of course, and to take a bit of a back step. So hence my decision to go for early retirement at the end of June. It took the company by surprise, and it was very warm feeling to see people coming up to you and saying, but you know, I will always be around. And the next step is probably to be a consultant. I'll take a sabbatical year for a year, because I have some personal projects to look after and my child to look after as well. And then I'll come back as a consultant. I think I have a number of cards in my hands, not only as an attorney on transactions giving legal advice, but also in terms of corporate governance scorecard, if companies want advice and help to structure themselves. One can act as a director as well, an independent director. And there's the whole world of IML, CFT, which is coming up, where one can put some technology in and create a better world. So there are plenty of things happening at the moment. And even the legal world is changing with tech, smart contracts and so on, coding. So I'd like to go and look into all that. I was last at school 25 years ago, so I'd like to go back to school again.
Yes, why not? Well, I wish you all the very best in your future careers, and thank you for making the time to speak to us today.
Thank you very much, Joanne.
Excellent.
It's a great initiative.
Thank you.